Hi, I'm firearms attorney Gilbert Ambler, and I'm here today to talk about the rough week that the ATF has been having, specifically with respect to the Cargill decision. And I know that there are going to be lots of YouTube videos being shared this week about people that think that the Cargill decision is all sunshine and rainbows. And there are certainly some good things, but today I want to provide you a bit more of a balanced, perhaps nuanced take on what the Cargill decision actually means, because there are some good things, but there are also some concerning signs. We're going to talk about those signs today. Before we dive into it, however, if you have not yet hit that subscribe button, what are you waiting for? Hit that subscribe button, like, comment with your thoughts, share with your friends. That way you and your friends keep getting these important Second Amendment related videos. Now, and I'll tell you, your comments are important. The more you comment in it, the more you'll bump, because that's what we're talking about today, bump stocks, the more you'll bump that video in the algorithm. So go ahead and comment for us. All right, we've talked about this Cargill case previously. We all know that it was a bump stock case, and frankly, the Supreme Court got it right here. Bump stocks are not machine guns. They do not meet the statutory definition of a machine gun, and therefore the ATF was wrong to classify them as machine guns. In essence, that's what the Supreme Court said. There are a couple of shining things here. Number one, huge benefit. Everyone recognizes this. Everyone's going to be talking about this. The fact that the Supreme Court decided this way bodes well for future challenges to the ATF's authority, predominantly with respect to the pistol brace rule, which of course was also struck down, vacated this week down in Texas. And so should the ATF appeal that ruling, it's not going to go well for them at the Fifth Circuit Court of Appeals, so they would be relying on the Supreme Court to do something. Here they get a quick look at how the Supreme Court views them going beyond their statutory authority, so it's not going to go well for them. In my opinion, this ruling really sort of hammers home the fact that the pistol brace rule is dead. Same thing with respect to their rulemaking regarding personally made firearms or 80% firearms. That case is coming up before the Supreme Court. Will it get vacated and remanded in light of this case? I doubt it. I doubt that they will vacate and remand. I think they will still hear it and issue a decision on the merits there. However, this case should inform what they're going to do in that case. I think the ATF there also exceeded their statutory authority. A second bright spot that I really see in the Cargill case comes not from the majority, but from the dissent. From the dissent, you say? Yes, Justice Sotomayor, in writing the dissent, was trying to lay out for the public how scary bump stocks are. A lot of her dissent is focused on the idea that machine guns are scary, okay? And bump stocks, in her mind, are machine guns. Now, bump stocks, without any firearm to attach them to, however, are not scary at all. They're just pieces of plastic. So what does Justice Sotomayor do? She starts off her dissent by saying bump stocks get affixed to commonly available semi-automatic rifles. We'll post a screenshot of her comments here. Commonly available semi-automatic rifles. And kudos to a colleague of mine, Oliver Krabcheck, for recognizing this and pointing this out. What's she doing here? Well, she is inadvertently, in trying to describe how scary bump stocks are, acknowledging that semi-automatic rifles are in common use. And this is important because there are a multiplicity of, quote, assault weapon cases currently pending before the Supreme Court. And if the Supreme Court takes one of those, Justice Sotomayor is going to have a very difficult time claiming that semi-automatic rifles are not in common use. In fact, she has already conceded that they are in common use here. So that's a bright spot and something that we get to be excited about for future cases. What's not so exciting? Well, I think there's two things that are not so exciting here. The first of those two things that is not so exciting is the fact that Justice Alito should have written a concurrence saying, although I concur in the result, I separately believe that bump stocks and machine guns are protected by the Second Amendment. That is not what Justice Alito did. Apparently, and there's a bunch of controversy with Justice Alito and flying upside down flags outside his home and whether he did it or his wife did it, but apparently that must have him running scared. Because instead of saying something nice about the Second Amendment, which is typically what he does for us, he instead said, Congress, you should go ahead and ban bump stocks. He said, didn't mention the Second Amendment at all, because apparently in his view, it would be constitutional to restrict machine guns and restrict bump stocks as machine guns should Congress do it instead of the ATF doing it. And that is, of course, concerning because we would have much rather seen a decision where he said, look, if you were to ban bump stocks as machine guns, that would present serious Second Amendment concerns. We didn't get that. In fact, we got just the opposite. This is a concerning sign for any other NFA-related challenges that might come before the court. I don't know that we can rely on Alito's vote. I think we can still rely on Justice Thomas's vote. Don't know about Alito's. And of course, the rest of the court is more concerning. Speaking of Justice Thomas, that's the other concerning thing here. I had been holding out some hope that Justice Thomas might be writing the Rahimi decision, and in the Rahimi decision essentially saying, I didn't stutter and Brune, I meant what I said. There's no historical analog here for the government to do what they're doing. The fact that Justice Thomas wrote the Cargill decision, however, means it's far more likely that there is another justice writing the Rahimi decision, and if it's somebody other than Thomas writing the Rahimi decision, I think it's probably not going to be positive for us. Now, if you enjoyed this content, go ahead, hit that subscribe button. If you have thoughts about what we talked about today, or if you've got questions about what we talked about, hit that subscribe button. Until next time.